हेलो एवरीवन, इस वीडियो में मैं आप लोगों के साथ रीसेंट सुप्रीम कोर्ट के जजमेंट से रिलेटेड एमसीक्यूज डिस्कस करूंगी. सो लेट्स स्टार्ट. फर्स्ट क्वेश्चन इज, इन विच ऑफ द फॉलोइंग केस सुप्रीम कोर्ट रिसेंटली गिव स्प्लिट वर्डिक्ट ऑन हिजाब इन एजुकेशनल इंस्टीट्यूशंस? एंड आंसर इज एशाद शिफा वर्सेस स्टेट ऑफ कर्नाटका and others, 2022 Supreme Court. It was a two-judge bench decision. Justice Sudhanshu Dhulia held that there shall be no restriction on wearing hijab anywhere in school and colleges in Karnataka. He said that secularity means tolerance to the diversity. And the second judge was Justice Hemant Gupta. He held that wearing hijab is not an essential religious practice, unlike the kirpan worn by the Sikhs. He held that Karnataka's government hijab ban promotes environment favoring equality. He said that secularity means uniformity, and he upheld the Karnataka High Court ruling validating the ban. So it was a split judgment between two judges. Justice Sudhanshu Dhulia gave judgment against the ban, and Justice Hemant Gupta gives judgment in favor of the ban imposed by the Karnataka government. Next question is, in which of the following case Supreme Court recently extended the right to safe and legal abortion up to 24 weeks to the unmarried and single women also? So it was protected only for the married women under the Medical Termination of Pregnancy Act, which was recently amended by the central government. However, it was not allowed for the unmarried and single women, but now the Supreme Court extended this right to the unmarried and single women also, and the case name is X versus Health and Family Welfare Department, 2022 Supreme Court. In this case, Supreme Court has extended the right to safe and legal abortion up to 24 weeks to unmarried and single women also, saying that it is a right of every woman to make reproductive choices without the interference from the state under Article 21. And it was also protected under Article 14 because it was not based on reasonable differentia. The differentia which was created by the government in the act, that only married women will be allowed to abort up to the 24 weeks. However, unmarried women were not allowed. So it was violative of Article 14 also. Next question is, in which of the following case Supreme Court recently upheld the constitutionality of EWS quota, that is economic weaker section quota, that is 10%, which was added by 103rd amendment, 103rd constitutional amendment under Article 15 subclause 6 and Article 16 subclause 6. So its constitutionality was challenged, and recently 5 judges bench of Honorable Supreme Court upheld the constitutionality in the case of Janhit Abhiyan versus Union of India, 2022 Supreme Court, and the ratio of the judgment is 3:2. So 3 judgment has given the judgment in favor of constitutionality and 2 are the dissenting judges here. Dissenting judgment is given by Honorable Chief Justice of India UU Lalit and Justice S. Ravindra Bhatt, and the majority judgment is given by Justice Maheshwari. What it said is, reservation is an instrument of affirmative action by the state so as to ensure all-inclusive approach. It is an instrument not only for inclusion of socially and educationally backward classes. Reservation for EWS does not violate basic structure on account of 50% ceiling limit, because ceiling limit is not inflexible. However, the dissenting judgment given by the Honorable Chief Justice of India UU Lalit and Justice S. Ravindra Bhatt said that reservation on economic criteria is per se not violative. However, by excluding the poor among ST, SC and OBC from economically backward classes on the ground that they have enjoyed the benefit, that made the 103rd amendment unconstitutional in nature. So what these 2 judges had said actually, that this 103rd amendment is not per se violative, but because from EWS quota SC, ST and OBC are excluded. That's why this is violative in nature. Next question is, in which of the following case Supreme Court recently stayed the application of section 124A, that is relating to the offence of sedition under Indian Penal Code, and the name of the case is SG Wombat-Kere versus Union of India 2022. In this case, 3 judges bench of Chief Justice N.V. Ramanna, Suryakant Justice and Justice Hima Kohli had urged the state and central government to refrain from registering any FIR, continuing any investigation, or taking any coercive action by invoking section 124A of IPC while this sedition law is under consideration. So this was challenged before the Honorable Supreme Court, and in that case Supreme Court has given the direction to stay of any filing of any FIR or for any investigation until and unless the judgment came in this case. Next question is, in which of the following case Supreme Court recently imposed a ban on two-finger test or pre-vaginum test in order to check. This test was conducted on the rape survivors for the examination of the vagina. So the court in this case imposed a ban on this practice of two-finger test or pre-vaginum test. Next question is, in which of the following case Supreme Court recently laid down the guidelines regarding recording of evidences of vulnerable witnesses, and the guidelines relating to recording of evidences and the meaning of vulnerable witness also expanded in this case, and the name of the case is Samruti Tukaram Badade versus State of Maharashtra 2022 Supreme Court. In this case, Supreme Court expanded the definition of vulnerable witness to include age-neutral victims of sexual assault under POCSO, and also victim under section 354, 377 Indian Penal Code who are suffering from mental health. And some guidelines also laid down regarding the recording of evidences of such vulnerable witness, that protection must be provided to them. They must not be confronted by the accused person. In cross-examination, insulting question must not be asked from the witnesses, and also that court will ensure that cross-examination must be conducted in camera. Next question is, in which of the following case Supreme Court recently laid down fresh guidelines on arrest and bail. So regarding arrest and bail, one of the landmark judgment name is Arnesh Kumar versus the State of Bihar, and recently Satyendra Kumar Antil versus Central Bureau of Investigation 2022. In this case, Supreme Court said that investigating agencies and officers are duty bound to comply with the mandate of section 41 and 41A of Criminal Procedure Code, and the court will have to satisfy themselves on the compliance of section 41 and section 41A. Under section 41 Criminal Procedure Code, word may has been used there, and it is not compulsory for the police officer to arrest a person when any cognizable offence has been committed. So if any cognizable offence has been committed for which the punishment is less than 7 years, so in that case police officer need not compulsorily to arrest the person, rather he must comply with section 41A of Criminal Procedure Code. Section 41A of Criminal Procedure Code provides that the police officer shall, in all the cases where the arrest of the person is not required under section 41, so police officer shall issue a notice directing the person to appear before him, and as far as that person comply with such notice, appear and cooperate with the police officer, so there is no need to arrest that person. So the main objective is jail is exception and bail is the rule, and that emanates from Article 21, that bail is the rule and jail is exception to protect the right to life and personal liberty of individual. The court has made a specific observation in the form of an obiter dicta that the government may consider the introduction of a separate law like Bail Act to streamline the grants of bail. Recently also this issue has been in news that bail must be granted by the trial courts in most of the cases. Next question is, in which of the following case Supreme Court recently held that the victim has a legal right to be heard at every step post the occurrence of the offence? And the case name is Jagjit Singh versus Ashish Mishra, 2022. So this is a famous case relating to Lakhimpur Kheri killings, and in this case the three judge bench of Chief Justice N.V. Ramanna, Suryakant Justice and Hima Kohli Justice held that a victim within the meaning of Criminal Procedure Code cannot be asked to await the commencement of trial for asserting his or her right to participate in the proceeding. He or she has a legally vested right to be heard at every step post the occurrence of an offence. Such a victim has unbridled participatory rights from the stage of investigation till the culmination of the proceeding in an appeal or revision. So in this case, Honorable Supreme Court specifically talks about the legal right of victim to participate in the proceeding after just occurrence of the offence, and not to wait till the commencement of the trial before the court. Next question is, in which of the following case Supreme Court recently laid down the guidelines regarding the death penalty? And in case of Manoj and others versus State of Madhya Pradesh, 2022 Supreme Court. In this case, Honorable Supreme Court held that there is urgent need to ensure that mitigating circumstances are considered at the trial stage to avoid slipping into a retributive response to the brutality of the crime. The state must produce material before the session court disclosing psychiatric and psychological evaluation of the accused person. This will help in establishing the proximity to the accused person's frame of mind, if any, at the time of committing the crime, and offer the guidance on mitigating factor. So in India, we follow the reformatory theory and not retributory theory. In case of Bachchan Singh versus State of Punjab, Honorable Supreme Court has held that in only rarest of the rare cases, death penalty can be awarded. So in this case, Manoj versus State of Madhya Pradesh, Supreme Court has given the direction that psychiatric and psychological evaluation of the accused person, so material relating to that must be produced before the session court. Next question is, in which of the following case Supreme Court recently held that even after the final disposition of special leave petition, the plea of juvenility may be brought in any court at any time? In case of Vinod Katara versus State of Uttar Pradesh, 2022 Supreme Court. Next question is, in which of the following case Supreme Court recently held that no individual can be forced to be vaccinated? And the name of the case is Jacob Puliel versus Union of India, 2022 Supreme Court. In this case, two judges bench of Justice L. Nageshwara Rao and Justice B.R. Gawai held that bodily integrity is protected under Article 21 of Indian Constitution, which provides right to life and personal liberty, and no individual can be forced to be vaccinated. Next question is, in which of the following case Supreme Court recently upheld the Union government's one rank, one pension policy for the retired army officers? So the name of the case is Indian ex-servicemen Movement and others versus Union of India and others. This is also recently passed in 2022. Next question is, in which of the following case Supreme Court recently refused to set aside Gautam Navlakha's house arrest order? So in the case of Gautam Navlakha versus NIA 2022 Supreme Court, in this case Supreme Court has granted the order to keep the Gautam Navlakha in house arrest. And recently, two judges bench of Justice Joseph and Justice Rishikesh Roy permitted Mr. Navlakha to be shifted to house arrest from jail for a month on November 10th, subject to a host condition. He was asked to deposit 2.4 lakh to fund his security cover and other surveillance when he is placed under house arrest. The court permitted him to be shifted due to his ailing health. Next question is, in which of the following case Supreme Court recently held that there is no provision of time restriction in the applicability of an anticipatory bail? Anticipatory bail, which is granted under section 438 of Criminal Procedure Code in case of non-bailable offences, and the name of the case is Shushila Agrawal versus NCT of Delhi, 2022 Supreme Court. In this case, Supreme Court held that anticipatory bail may be granted for till the decision of the case. Next question is, in which of the following case Supreme Court recently laid down the guidelines regarding maintenance? And very landmark judgment is Abhilasha versus Prakash. This is of 2020, but very important because guidelines are laid down by the court for interim maintenance as well as for permanent alimony also. Next question is, in which of the following case Supreme Court recently held that the daughter of the co-partner shall be by birth become a co-partner in her own right in the same manner as that of the son under Hindu Succession Act 1956. So after the amendment 2005 amendment in Hindu Succession Act, now the daughter was become a co-partner, and recently in the case of Vinita Sharma versus Rakesh Sharma 2020 Supreme Court 3 judges bench comprising of Justice Arun Mishra, Justice M.R. Shah and Justice Abdul Nazir held that daughter has become a co-partner in her own right in the same manner as that of the son. So this was the last question. I hope this video will help you regarding the names of recent Supreme Court judgments. If you like the video, please comment and subscribe this channel for more such relevant videos.